Hello, thanks for joining us for Data Privacy Compliance. My name is Raphael Zahardin of Lewis, Brisbois, Bisgard, and Smith, and I'm the moderator. This webinar is part of the Financial Poise webinar series, Corporate and Regulatory Compliance Bootcamp. Slide 7 provides a summary of the episode, and on slide 8, you'll see a summary of the series. Speaking of the slides, we're not going to walk through them in any sort of order. You don't have to listen to us read any slides. We try to make this as conversational as possible while still trying to get through the racehorse that this is in an hour. Do keep the PowerPoint handy. It's helpful as a reference guide, and every once in a while we may rely on a slide, though I don't think we're going to be running through those today. Our panelists are Jamie Wida of Bradley Arendt. Jamie is several Bradley lawyers have done this particular webinar, and they've all been excellent. Rita Gary of Howard and Howard. Pia Thompson, who's general counsel at Lawson GC, which is a very interesting and wonderful project of hers, her company, where she's got provides general counsel services for folks around the country. And then Kyle Miller of Denton's, who's done this panel with us before, and we'll get a lot of insight from Kyle. My name is Raphael Zahardin, and I'm a partner, as I said, at Lewis Brisbois. And we appreciate that you're not spending your time, money to attend the webinar to hear infomercials about us, but you can read more about us on slides 139 through 143. This webinar is a production of Financial Poise. To sign up for the great free weekly newsletter, go to financialpoise.com, or you can shoot an email to info@financialpoise.com with the word subscribe in the subject line, and they will get you hooked up. If you're attending the live premiere of this webinar, you can submit questions using your web portal. If you're watching this on demand or have any questions after the webinar, send that same email to info@financialpoise. Just include your question, the name of the webinar episode, and we'll get back to you with an answer. We actually enjoy follow-up, and sometimes we don't get a chance to get to some of the questions. One last note, thank you to our sponsors, Mood Online Cannabis Dispensary, Type to Learn, typing learning software by Sunburst Digital, and MassX Asset, which is a asset sales online service that everyone should check out. It dovetails perfectly with the Daily DAC and some of the other wonderful Financial Poise partners and divisions. All right, let's get this started. This is one of my favorite parts of the webinar series. This is the Data Privacy and Social Media Compliance webinar. This pervades everything we do. It is on the tip of everyone's tongue. It's these different information and technology issues pervade now the Dow Jones. We see things every single day. There's a wonderful story I like telling about going to big company. I won't name who they are, but they're a television production company, not on the West Coast. And you go in and they have a war room that's got a map of the world, and they're showing where the cyber attacks are coming into the US and how they're being stopped. And it's a real-time manned by 15, 20 people. Pretty impressive. And I doubt that there are many companies that don't have a similar capability and have a similar issue. So we're going to ask panelists to provide a quick introduction into the regulation of data privacy and protection. We're going to talk about the types of data to consider in this context, certain types of threats, key relevant laws in the US, as well as foreign laws most relevant to US companies. We'll go over the regulatory landscape. We'll focus on some key industry sectors and some new developments, and we'll take a look at how data privacy and protection is being addressed in different contexts and in different places. So I'm going to start off by going to Jamie, and I'm going to ask her basically what types of information should we be worried about protecting?
Thank you so much for that question. Again, I'm Jamie Wida. I'm a litigation attorney at Bradley A. Rant, and I practice out of our Houston, Texas office. So there are 5 categories I'm going to go over about the information we should be concerned about protecting. The first is going to be the information that's protected by law. The most common one that we hear about is going to be personal data. That's information that can be linked to a specific individual. We've seen a lot of regulations come out in several different states about this kind of data. That's going to be like name, birthday, your social security number, driver's license number, mother's maiden name, very specific data that can trace you to a specific person. There's also non-personally identifiable data. That's going to be like zip code, area code, city, state, gender, and age. And that's because, yes, that is some type of data that could link you to a person, but it's not so it's not individual as the other data. And there are laws that protect this data, like the Federal Trade Commission Act, HIPAA, the Graham-Leach-Bliley Act, and the state privacy laws that I talked about just a second ago. There's information that you have an obligation to keep if you've represented to your customers that you're going to keep it confidential. There's going to be industry specific or regulator specific requirements like the New York State Department of Financial Services and payment card industry data. There may be obligations for you to keep information confidential that you have stated by contract that you would keep confidential. And then confidential corporate information such as client data. That's other people's information that you or your company has in its possession, like customer list, prospect list, trade secrets, business plans, employee list, and other information like that.
I was talking to one of our sports lawyers the other day, and I asked them, where did your height and weight go in, because you see that published everywhere. And he said, well, that's not really medical or private information because it's usually fake anyway when the athletes put them up there. So I don't know what the real answer is to that, but that is a question people ask. So I'm going to turn this over to Pia, and I'm going to say, so Pia, who should care about these requirements? Who does this apply to? And I know it sounds kind of funny, but some people may think, hey, this doesn't really apply to me. And they might find, they might be surprised by exactly how broad this it covers different peoples and entities.
Absolutely. So it is extremely broad, and best practices is to understand that it does apply to you, and it's going to really be related to scope. And so the things to remember is that you've got different state requirements. I think every month a state is passing a new privacy law that is just a little different than the other states' laws. One of the best practices to do is to pick the most, if you're in multiple jurisdictions, is to pick the most restrictive one and apply that to everything. Unless you do have the resources and the capabilities to individualize your systems. So that's the first overlying thing. The second is, one of the things that's starting to happen now are your employee files are being subject to all of these privacy requirements. And that's something that's very new. So, and I think your HR folks won't be as familiar. It's something you just want to check in with them on and see if your HR people need any help with satisfying the employee requirements. And so I think the biggest thing when it comes to industry is, in the hierarchy of things, right? Your most sensitive is always going to be consumer data, individual consumers. So think about it just holistically with your industry. What kind of stuff do you have that touches consumers? And yes, there's other stuff, but it's kind of as you go up the food chain. And then the other thing that you need to think about is, if you are internationally involved. You have the GDPR, and there's also continuing changes. I can't tell you sitting here right now if Canada is the same as us, right? And so you definitely want to make sure that all of your jurisdictions are covered. And then you need to understand your exceptions to compliance with the privacy laws. And so it sounds like, oh, you don't have to comply with privacy laws if you have an exception. But it's not as easy as that. It's usually you have to comply with something else, and that's what carves you out of the privacy laws. So the way to think about it is if you have regulators that require you to keep stuff, so that if you got a request to delete, you couldn't comply with it, that's the type of exception I'm talking about.
Okay, okay, that's very helpful. Kyle, you're in our batting lineup. You're in a strong position here. So when we're talking about data privacy and data protection, what are some of the threats that are traditionally the ones you look for, and is there anything unique? Because I've been told that one of the reasons that data and cybersecurity breaches are not held against boards of directors, particularly in places like Delaware where there's very high protections, is that you're not supposed to be perfect. You always, it's changing so rapidly. It's very hard, and really, it's how you react to the breach as opposed to trying to prevent it. So, what are the types of things we're seeing from the very creative criminal element out there that are behind a lot of the data breaches?
The threats to organizations on how they manage data range from the very sophisticated to the absolutely banal and everything in between. And you raise a good point about not having to be perfect, and it's true that any organization that has suffered a data breach, they might have had extraordinary protections in place, but if you're playing defense and you don't want to get scored on, you can be, you can be almost perfect. You can make one mistake and let an attacker through. One mistake can sink you, whereas if you're an attacker, you can try and fail a million times, but you only need one of your many shots to get in. So even though the last few years saw a rise in successful zero-day vulnerabilities, the most common attack for most companies is still phishing, business email phishing, where your users will receive emails from threat actors alleging that they are from a trusted company or another employee, and ask for sensitive information or ask them to click a link, which will then load malicious software. While that has been consistently one of the top attack vectors for several years now, it's becoming even larger with the rise of generative AI, whereas now individuals don't even have to write the email to copy and paste many times, but can use generative AI to mass create email that target specific individuals. The nightmare scenario for many organizations is a ransomware attack, where your entire system may be encrypted so that it's entirely unusable. So if your organization uses email to communicate along with a voice over IP phone system, you might find that your entire communications are offline. The threat actor then wants to levy a ransom to give you the keys to unencrypt your systems. They might exfiltrate data and want a second ransom to prevent that data from being published and exposed, and may even ask for a third ransom so that they won't tell the public, so they won't announce that they've compromised your system. Ransomware is a very common vector. But while you're looking out at these threat actors that are targeting your organization, you also have to be aware of the simple or maybe just boring vulnerabilities that you have. that affect many organizations, such as an insider threat, an employee who's sending information to their own personal email account, or copying files to a flash drive that they then misplace. So there are many ways data can unlawfully leave your organization, and as we'll discuss throughout this CLE, it can have major impact for your organization when that happens.
Thank you, Kyle. And certainly not least, but next, Rita, can you, now we've kind of scared everyone. You know, this is like that Scared Straight show that used to out there. We've told that, you know, it could be you, and here all the bad things could happen. So Rita, can you give me a little bit of an idea of the legal and regulatory landscape in the US that applies to this area?
Sure. Well, I think most importantly, for purposes of this discussion today, let's talk about the fact that we have none, zero federal US data privacy law for consumer personal information. And despite, you know, a lot of efforts that have gone into trying to get us to that point, we have developed a series of patchwork laws, both federal and state level laws, that are designed to help protect consumer information. At the federal level, we pay attention to industries and certain commercial activities, healthcare, banking, financial institutions, and that sort of thing. Those are not new, and those are those areas where you might be exempt from other comprehensive state laws. But they also all impose a lot of requirements on businesses. Additionally, and we've had these for quite some time, 50 states have breach notification laws, because when you have personal information that's exposed, personal identity theft going on, that happened, and that was a shocker for everybody. So we decided to do, every state quickly decided to do a breach notification requirement when there was a known breach. And it was in 2018, well, really the beginning of 2012, but in that early part of the 2010s that we got to the build up to GDPR in Europe, which sort of gave impetus to that in the United States, but California led us down the path early with CCPA, the California Consumer Protection Act. Now that's designed for consumers' personal information, data protection, and privacy. And they built into it through the new California Privacy Rights Act, additional safeguards and consumer rights on their data. That sort of sat there for a while by itself, probably about 2 or 3 years. And then suddenly in the last year and a half, 5 states blossomed quickly. And then there's been more now, 10 more that have enacted legislation that will go live by 2026. And every day it's changing. And these patchwork laws make it difficult for businesses to learn to comply, to develop a strategy, as Pia mentioned. And it's also one I agree with. You pick the most restrictive, you design your data governance around that. Unless you have the ability to color code, I've already joked about, if I could color code or state code every person's little information thing and what state they live in, but the poor people in Iowa, well, not anymore in Iowa, the poor people maybe somewhere in the United States who have zero consumer data privacy rights. I don't know how you would pick on those guys and say, I'm sorry, I'm not requesting, I'm not going to respond to your requests for any of your ability to exercise privacy rights. You have to be mindful of the fact that you not only collect information, but you send information out to third parties, and that's being processed by somebody else for which you have really contractual responsibility and legal responsibility. So you have to push downstream to those processors those responsibilities, that these laws are designed to help us all become more aware of our own privacy, our data privacy rights, and the protections that businesses are required to give us. Of course, obviously, we're all familiar with, non-disclosure agreements and other sorts of things. And so you still have to be mindful that, you have contractual obligations as well as legal obligations. But as you can see, the landscape is very littered with no real comprehensive across the board coverage for consumer data, unless it's in a context that's already governed by healthcare, credit reporting, banking, and children. So it is a difficult task to build a compliance strategy around that.
Well, it gets even more complicated, right, Jamie, when you start talking about, and maybe why do we care about the global regulatory environment?
Well, we care about that because there are some businesses that have ties with other countries, so that brings in other countries' laws. I'm going to talk about quickly a couple of them that are really important. In the United States, the California Consumer Privacy Act was the first comprehensive privacy law to be passed in the United States, and that was just in 2018. We're talking about 6 years ago. This act gives consumers a right to know about the personal information that businesses collect about them, how it's used, how it's shared. Consumers have the right to delete that information. They have the right to opt out of the sale or sharing. I know you guys have seen it before. There's pop-ups all the time. It says, this is how we use your information. We're going to sell it. And, we may not have paid as much attention to it, but it's very common now. People are really starting to pay attention to it. The California Privacy Rights Act was a ballot initiative that was on the November 2020 ballot, and that just created more consumer rights. People are really concerned, and that's probably a result of COVID. More people were on the internet than ever. They were doing things online that they used to do in person. So they were just more willing to share data. That created a lot of issues. So as a result, this is something that passed on that ballot. The GDPR, which we haven't talked about today, that's the General Data Protection Regulation. It's for the EU. That is a much more strict privacy law for the European Union. And they sought to just be lawful and fair, transparent, limit the uses of data. You need to be getting the minimal amount of data from people, and it needs to be accurate data. There's also a lot of other countries that are introducing and expanding their data privacy laws. There's been Australia, China, Brazil, and at this point, over 70% of countries have data protection and privacy legislation. So to just bring that home, if you are doing business in other countries, you're going to have to pay attention to the privacy laws, not only in the United States where you are, but where your businesses are in other countries.
Well, and now we've got a what some might argue is a forced expropriation, which is something we don't usually do here in the United States. We're usually subject to it with TikTok, based upon national security issues and privacy concerns of people mining U.S. citizens. And you've got a lot of people that you even look at the questions, they don't really understand like how a lot of these companies make money. If you have watched some of the congressional testimony or the questions being asked. So Pia, we covered some of this kind of at a high level, but I want to get a little more granular before we get into industry specific requirements. Can let's break down some of the things we covered and dig into some of the things, because I think we're now at the point where we can give a little more detail. So what types of information and data do companies need to protect, and where does this data exist? Where is it?
So there's so much now with everything being electronic, right? And people provide all sorts of information to get access to free resources. So it's not even just when you're selling stuff, but when you are selling things, you're getting a whole lot of information. And you're getting passwords, but you're also getting things that, again, PII, the way to think about it is, can you take this information and re-engineer it to get to the human being that it represents. And so one of the things that I think is very interesting now is that there are a handful of women who don't change their surnames when they get married and have different surnames than their children. And therefore, one's mother's maiden name is very readily accessible in today's day and age. And so I think that is something where that question at some point is going to need to go by the wayside, because it's become something that used to be a massive secret, right? Nobody knew. Kids half the time didn't even know. So I just think that's one of the ones that's interesting.
Well, Pia, I always laugh at that, being Chilean and Colombian, because my name has my mother's maiden name in it, right? It's Rafael Zahardin Aravena, right? So yeah, you're right. Now everybody else has copied the Hispanics. So
right?
right.
Exactly. So and then here's an interesting thing. So there's PCI, right? Credit card information that you put in
Right.
to, anywhere that you're buying something. And that's even brick and mortar. I don't want us to all think that it's just things on the computer. One of the things that's interesting about that is not all entities that take in credit card information need to be PCI compliant. And I think sometimes that's a confusing thing for folks. And the reason for that is there are all sorts of third-party payment providers that tokenize the credit card information. So they're the ones who are PCI compliant. And they send you some token that is not PII, that is not someone's credit card. And so you'll see a lot of that happening. Apple Pay, frankly, is something that does that. And so with merchants, right, Visa networks, all that kind of stuff, but even lending companies and other folks can avoid the expense of becoming PCI compliant. As far as business information goes, I'm not exactly sure how PII that is. There are other restrictions on that, trade secrets, breach of duty, those kind of things. So I'm not sure that's anything that needs to be so an item of concern for this group. It's like, oh my God, when you have everything done and you get to think about business information, like God bless. So one of the things is anonymized data, right? And it's so valuable. So if you can figure out a way to anonymize the data and sell it, like big data is where it's at, right? And it can end up being perhaps like a bigger revenue driver than your basic sales product. So the issue that comes around though is nobody can agree on what anonymized data is. And with AI and all those other things, one day is it going to be impossible to anonymize data, right? One day is it going to be impossible for any of us to have passwords? I don't know, right? The stuff's going to get faster and faster. So anyway, I think that those are some of the more granular details. And then maybe one day we'll have a separate seminar where we talk about kind of policy and whether we think there's a consumer in the world who cares about any of this and that this is all just for regulators. Because I don't know about the rest of you. All I ever do is click accept and figure out where to put my credit card in. But
Well, I won't make it a commercial for this particular browser, but there is a browser that I just love, that feeling of hitting that fire button and making everything get burned away. So I think I say, because I think once you get the choice, you say no, because I'm distrustful of anybody having my information.
well, again, we have to have another panel on that because I vehemently disagree. I'm 100% diametrically opposed to what you just said. So let's see who wants to listen to us talk about that.
Awesome. Kyle, so given this general landscape, can we talk a little bit about, well, what type of program, what kind of data privacy program should we set up? What are the kind of the core elements, the things to look at when you're looking at the architecture of one of these things, and what are some related best practices to kind of make sure that they're effective?
Absolutely. So to get your hands around privacy at your organization, the first step is to determine what data you have. So we've gone over the types of data that could be regulated under the US patchwork. But before you can even assess your risk, you need to decide or determine what you're already processing, right? So where is that data? What data elements do you have? What's the flow of the data through your organization? That's where it comes from, where it's stored in your organization, where it goes to, and then whether you're processing the data as to borrow a European term, the controller, or as a processor on behalf of another organization. And when you map that out, you've created a data map, and that's the step one, the first step to understanding the risk to your organization. Once you have the data map, you can work with counsel to determine which of the many laws from the U.S. patchwork and the global regimes apply, and then determine your obligations, which can be addressed through administrative controls like policies and procedures and training, technical controls as far as the actual security, the tools that you put in place, and then you audit those policies at least annually to make sure you're abiding by those best practices. Unfortunately, I think it's easy to tell by the broad conversation we're having here. You could spend all of your resources, all of an organization's time and money could be devoted to this. But the goal here is to identify your risks, and then on a risk-adjusted basis, put the controls in place that you need to comply with the laws, especially these new comprehensive laws that most organizations have to comply with. One key big component that US companies are having to face now that they didn't before, outside of a few regulated industries, is operationalizing data subject requests. So Raphael, you said that when you have the option to opt out, you do, but you don't always have the option. Pia disagrees. When the CCPA first came out, there were a lot of people that thought that that some of its opt-out requirements wouldn't be selected. That you say, oh, people write privacy notices and they're not read. People write terms of services and they're not read. You're not going to see many requests to the CCPA. I think a lot of organizations are realizing that that when they start to comply with the state laws that give data subjects rights to their data, they start to receive those requests to know what data they have, to disclose the parties they've given it to, in some cases to delete the data. And when you have limited timeframes to do so, you need to make sure that your policies, procedures are all in place, that your data maps are together, so that you can abide by these new laws in the United States.
That's great. Rita, can you tell us a little bit about insurance and how insurance plays a role here, if any?
Sure. I'll start by saying you could have done everything that Kyle had just suggested and still get attacked. And so your backstop for protection as a business that has done the data mapping, has a risk profile, and frankly, it's almost every business that I've ever dealt with does have a risk profile sufficient and warranting coverage for insurance. Because if you've ever worked a data breach like some of us have, the insurance becomes the lifeline for the company, with the very average low-level breach costing $4 million per breach. And that's just a low-level breach. You really have to have insurance. Now, the idea is to buy specific cybersecurity, cyber risk insurance to cover those specific cyber events such as fraud online and offline within and outside and around your company, ransomware situations, hopefully not 3 rounds of it, data recovery and restoration. If you've ever been through a forensic audit and you've had a data breach in your own business, you know how disruptive it is, and you have to hire experts to fix the problem and remediate the damage done. And if you have then and you're subject to a breach notification, you have to notify. That's very expensive as well. Sometimes you have to provide credit auditing, insurance coverage for those people who have been affected by the breach. And then ultimately, to get that coverage, you certainly have to pick the right limit. It has to be somewhat affordable, which is a relative statement. But then you also have to apply for and get it. And these days, it's much more difficult than it used to be. Your applications got to be true and correct, because if you say you do something in those applications that you don't do, and they find out, the coverage will be voided. So you really do have to do front office and back office work on that. And I would say every business should be looking into that as well, because it's not covered under general liability, policies generally. And if it is, it's a very computer fraud oriented coverage piece that doesn't cover a lot. So
Got it. That's very helpful. Jamie, who are the main regulators in the financial sector, and what, again, you can tag them up with the regulations or laws that apply, whether it's self-regulation or actual regulation pursuant to statute.
Sure, yes. So the main regulators for banks going to be the Federal Reserve, the Office of the Comptroller of the Currency, and the FDIC, or the Federal Deposit Insurance Corporation. For non-banks, it's going to be the Consumer Financial Protection Bureau, or the CFPB. So the primary laws that apply are going to be the Gramm-Leach-Bliley Act, and this act regulates all collection, usage, and disclosures of personal financial information. The Fair Credit Reporting Act, I know we have all heard of that. This act limits the circumstances under which consumer credit information can be used, and you have to let the consumers know if any of this information was used against them in a negative way. There's also something called Regulation SP that comes from the SEC. It requires brokers, dealers, investment companies, and registered investment advisors to adopt written policies and procedures to protect consumers' data, their records, their information. And it also requires that they dispose of the information depending on certain timelines. There's also specific state and sector regulators. There's something called the New York State Department of Financial Services. This regulation requires banks, insurance companies, and other financial services institutions to establish and maintain cybersecurity programs to protect consumers. This is really important because there are many financial services companies that are incorporated and regulated in New York. So it's really important to pay attention and make sure that you would be in compliance if you are in New York. And then if you're international, of course, the GDPR would apply.
All right. Pia, what areas are regulators in the financial services sector focusing on in 2024? You're on mute, Pia. Still on mute. You're still muted.
Oh my God. Okay.
Now we're
go.
back. Now we're back in action. There we go.
Right. So I think it's one of those things, a lot of it is, kind of platitudes. You better have a robust program. You're gonna see fines if there's, any type of incident. And so I think there are a couple things with that. It's FINRA, SEC, but I think it was Kyle who mentioned earlier, almost everything has to do with a breach. So they are not coming in the financial services area to make sure that you have a business continuity plan and you've actually done run throughs of it, and that, you know, you kind of have everything set to go in advance. It's really coming in after the fact and saying, well, what did you have set up? All of those types of things. I think also with many of the fines, and it's different when you are the company, but the fines, from everything I've seen based on revenue or profits of a particular company are rather small. So the number may sound big to people who aren't paying attention to the size of the company,
Mhm.
but I think companies should get everything in order, but you need to basically do the risk tolerance of your company, right? Because the reason it's impossible for the general counsel to get a third party in to do a risk assessment, or to finally get the execs to sit around the table and do a business continuity plan, breach response table exercise is because everyone has better things to do than spend time on that, because it doesn't contribute to revenue in any way. So I think to be a practical legal advisor in this space, you need to kind of see what the fines are, and if the fines would be material to your company, then you have some leverage to explain why you really need to take these steps, because the company won't be able to survive a fine of 7 figures. But if you're a company where 7 figures doesn't really matter that much, and you could lose 8 figures by doing these table exercises, right? There needs to be some legal and business discussions around how far you're going down this, because there are realities where the general counsel and outside legal counsel can't get anyone to do this stuff.
So Kyle, thank you. Okay, so Kyle, let's talk about retail a little bit. So that's a place where we hear about breaches a lot. Equifax, Yahoo, others. Give me a little bit on the circumstances of some of those major retail data breaches, and how that affected risk management.
Yeah, so one of the greatest values that retail organizations have is the data of their consumers. Of course, consumer data is protected, and it's one of the risks they have if it's misused or unlawfully accessed. So you mentioned Equifax. One of the largest reported data breaches and subsequent fines. There were 147 million individuals affected, and the FTC negotiated a settlement with them for $425 million. So while we should know and recognize that the average cost of a low-end breach is around $4 million, we also know that there are significant ones that at least the pure penalty was $425 million, and that's not including the cost to remediate their systems, as well as legal expenses and reputational costs as well. Another risk to organizations that go through data breaches was seen in the Yahoo breach, where around 500 million accounts were affected, and it substantially altered the sale process that it was going through. This was announced shortly before most of their assets were acquired by Verizon. It reduced the sale price by $350 million, and they had to renegotiate how to handle the ongoing costs of of this incident. They split the costs post-closing, but then a $35 million penalty was assessed to the company that was then formerly known as Yahoo. So there's a risk to the value of your company when it comes to data breaches. And the last one I'd like to point out is was in the news fairly recently when Uber had a series of breaches that affected around 57 million individuals. In the last few years, their former chief information security officer was criminally charged with a cover-up and impeding an investigation. So while we certainly talk about costs to the company, there is at least that example of criminal charges brought against an officer of the company related to that breach. I'd also want to add from a retail perspective, when we talk about these comprehensive state laws, there's been 2 enforcement actions brought under the CCPA, and they were both against retail organizations, and neither one was for a breach, a cybersecurity breach, but instead a disclosure of consumer data that did not follow the law and the regulation as it was applied by the California Attorney General. So even if you're not being targeted by a threat actor, how you use the data and how you disclose the data may still open your retail organization up to liability to regulators.
Thanks, Kyle. Speaking of regulators and government enforcement, Rita, what are some of the things you have to look out for if you're a retail company and what can you expect if something goes wrong?
Well, I think if we take the largest federal data privacy security regulator is the Federal Trade Commission, exercising its authority under Section 5 to prevent unfair and deceptive practices related to consumers. And they use that Section 5 power to identify what they consider to be unfair and deceptive in the context of these breaches, and also the non-compliance with other provisions of laws that apply to them. This can be failing to comply with companies' stated posted privacy notices, which is one of the areas the FTC has been very active in. And you really have to convince clients to walk the talk, because if you don't walk the talk and you're saying something in your privacy practice that you do, but you don't do, or you're that's deceptive. So they basically have been super active as an enforcer of the consumers' rights to live in a world where they're free from unfair and deceptive practices, and the fines are substantial. One of the probably most egregious ones I've seen recently has to do with tracking technologies, and that has not in the breach context either. And that was Better Health, which was a California-based mental health care counseling company. And they were using tracking technologies to sell and share, same thing in California, the sensitive health information of people who sought out and paid for health counseling. They were fined $7.8 million. That was in July of 2023. Some of those funds went to repay consumers, but they basically were also ordered to get affirmative express consent with people before disclosing personal information to third parties. This included Facebook, Snapchat, the French equivalent of Facebook, and others, and Instagram and such, so that they were disclosing personal information. Then those people could retarget ads to those consumers based on their profiles in the sharing. They have to direct third parties there, and those processors have to be subject to contracts that basically they will commit contractually not to share this information, and they have to minimize the data that they have and limit the time that they're using that information. So if you're a consumer of BetterHelp mental health counseling for a period of time, but you're no longer and you stop, why are you retaining my data? So the FTC is right up there. California has the now California Protection. There's too many acronyms in California. The CPPA, they actually have their own agency that came about with the CPRA. And those guys are quite active in terms of their push to get companies to be compliant with these exercising rights, people having the ability to exercise rights with undue interference. And data minimization is one of those areas. So if you're responding to consumer requests to access, delete, and so on, you can't impose burdens on the consumer to exercise those rights that are unnecessary. So really the compliance landscape to me, and I think the FTC under the current leadership is being very, very aggressive to enforce. There is a new COPA, which is the Children Online Privacy Protection Act, which is now gotten pretty stale since 1998. The 2.0 has come out, it's proposed, and they're strengthening those protections for online collection, use, disposal, disclosure of children and teens ages 13 to 16, which is a heightened area of concern, both at the state and now beginning at the federal level as well. So I don't think enforcement's going anywhere. In fact, I think enforcement is what's causing us to all of us begin to think about our own personal privacy in a more comprehensive way.
That's great. So we're up on 10 minutes left. So I'm going to ask our panelists to kind of come in, give us a quick answer, and then I think we're going to try to do a follow-up at the end. So I'm going to start off with Jamie. So we've had, let's see, in the last, I don't know, the recent past, a worldwide pandemic, the Ukraine conflict. Have those kind of crisis things or crisis events, have they affected how we look at data privacy risks? And just give me your thoughts on that issue.
Yes, absolutely. So they absolutely have. COVID-19, there was a huge uptick in malicious actors, specifically ransomware attacks. We hear about these all the time. Ransomware is literally what it sounds like. They take your information and demand money, ransom, to get it back. There are people that have had to pay to get it back. There's social engineering where there's these scams with criminals. They exploit your trust and they get confidential information from you, and you can end up paying money to these people. The pandemic made that worse because of the amount of information we were sharing online, and that information also ended up going to third parties. I just wanted to give a quick example of something I remembered going through during the pandemic. You would be asked, there's these little surveys that will pop up on social media to ask you kind of where you've been, about your exposure to COVID. And it was those kind of surveys that got us into this situation. And then quickly about Ukraine, there's malware wipers that have been used heavily during this conflict. In France, there was actually an instance where internet access was wiped out for 2 weeks from people due to these malware wipers. And there is insurance that you can get to protect you from these attacks. There's a commercial crime policy where a hacker breaches a financial institution and transfers funds from one financial institution to another. There's some insurance to cover that. And there's also some social engineering coverage, what I was just talking about when a victim's tricked into giving funds. So there are ways to protect you.
Yeah, the latest scam is the kids who have internships. Someone says, here's your first check. Oh, and what we want you to do is buy certain things that are important for your internship. And because kids are so savvy, they don't think twice. And it's that classic bounce check, and then your funds have gone out. And so it used to be just old people got hit, right? Because they didn't understand the internet. Now they're looking at it, let's put a twist on it. We're going to go to somebody who's really savvy and comfortable with it and then get them there. So Pia, quickly, what do you think about consumer data and how the FTC has been handling this issue?
So with respect to consumers, right, is they're very focused on things that are anti-competitive and deceptive and unfair. And I know that sounds like UDAP, which a lot of agencies are involved in, but that is a big focus of the FTC. And I have to say they do a very good job of sharing all their views in various essays and white papers, so that if this is your responsibility with respect to your marketing and your targeting and things like that, there are all sorts of resources that the FTC will provide for you. And so, excuse me, one of the things to think about, and I think this comes off of Rita's comments, right? And where she mentioned the healthcare company and consent and things like that. There is an aspect of common sense to these regulations. And so with, reaching out to marketing and things like that, you can ask yourself the questions, right? Would you be surprised if this company all of a sudden was sending you various marketing things? Are there things that would offend or surprise you if you heard from this other company?
Right.
Right. There are things that are pretty obvious in that. And so I know we're short for time.
Well, so Kyle, tell me a little bit about how social media fits into all this.
Yeah, how companies using social media is changing in light of both new laws like the comprehensive state privacy laws and sort of novel legal theories under old laws. So most companies will have to honor opt-outs, limit the amount of information that they transfer to social media companies about their customers, which can make advertising it less targeted, if not less valuable, and not strictly adhering to those requirements does introduce legal risk. Also, we've seen a wave of lawsuits against healthcare organizations and some actions by the Department of Health and Human Services against healthcare companies who were using social media for advertising purposes, put social media tools on their website. And while there's no new law or regulation, and all this technology has been around for many years, it's only in the last year or so that this theory was developed and has been used successfully against a lot of healthcare organizations, and that could spread to other regulated industries as well.
So Rita, I'll ask you pretty quickly. We talked a little bit about it, but what about a comprehensive federal law? Is there anything that's come close, and where are we? Just, your quick thoughts.
Real quickly, want everybody to be aware, because this is the first time since 2018, after going through 20 pieces of proposed legislation, we might have some real strength. The American Privacy Rights Act was brought forth as a draft document on April 9th of 2024. April 17th, they had congressional hearings. This is bipartisan, bicameral supported legislation designed specifically to institute a federal comprehensive data privacy protection law for consumers. It applies to all businesses, except there is a small window of exceptions for small businesses, but they're really quite focused on corralling social media companies and big tech and data brokers, heightening those requirements with respect to those people to protect children and others who are vulnerable, and also to give all of us rights to control our data and the ability to sue and preempt state laws. Fingers crossed. I happen to support a federal comprehensive legislation to avoid the patchwork, but we shall see.
And Jamie, we've heard about GDPR, and can you kind of tell us, like, why is or is it still true that the U.S. and EU have different approaches to privacy?
Yes, that is very, very true. The biggest thing is that there's just a different mindset when it comes to the US and the EU regimes. So the GDPR is designed not so much to regulate businesses, but more to protect the consumer's rights, so more of a personal privacy right. And for companies that do business in the EU, they need to be really careful and make sure that they're abiding by those laws, because people have been charged fines, very frequently because they're not abiding by those regulations. It's kind of difficult to determine where to draw the lines, but someone mentioned earlier, it may be better to just go by the GDPR's regulations so that you don't run into the issue of violating their law and getting fined.
And that brings up Pia. So can you share, and does it tie in a little bit to what's happened with the California Consumer Protection Act?
I think it does. And this goes to something so many of us has discussed, is setting up your company for the most restrictive laws. And sometimes you have to take a couple of states, because Virginia or Washington are more restrictive on certain pieces than California. So you're just going to need to go through. One of the big things with California, as with any privacy structure, is the data mapping. And so how do you even know what you have, let alone what you need to protect and provide extra security for? And that's one where I think you can get companies to expend resources, because in addition to privacy protection, there's tangible ROI you can get out of that, right? Organization efficiency, all those things are good, separate and apart from the mapping. So and the privacy protection. So I strongly encourage legal advisors to use the CPA and those various things to get significant steps along the line of protecting the company.
And Kyle, what do you expect to be the impact of this enforcement, and also on insurance, all sort of risk management of GDPR and the CCPA?
Well, there's certainly an increased risk of fines and penalties with the GDPR, all the other global privacy regimes that are seeking adequacy under the EU's rules, the comprehensive state laws. As each state jumps on board, that's another regulator, such as the Attorney General, that can bring fines and penalties. The CCPA is one of the few that offers a private right of action. We really expected to see a big wave of plaintiffs' lawsuits in California under the CCPA. There has been a rise in plaintiff-driven privacy litigation across the U.S. It's not clear that that's related to the CCPA. However, the American Privacy Rights Act, as proposed, that Rita discussed, has broader options for private rights of action. So there will be increased legal risks from regulators, from plaintiffs. And that will, of course, continue to push the costs of insuring against these risks higher.
So we're going to do something real quick. We're talking lightning round, 10, 15 seconds. What are your last thoughts on this, Jamie?
Yes, 10 seconds. Data mapping. You got to map out what kind of data you have, where it's going. You got to decrease these potentials for data errors and getting fined and getting violations. And you just need to understand exactly what you're collecting. You need to know how it's used, who it's shared with, what's the purpose, the retention. You got to protect your consumers. That's all from me.
All right, Pia?
Risk assessments, it should be part of your existing compliance program. Privacy, data breach, cybersecurity, all needs to be included. And take a look at your insurance.
And Rita?
Train your people to know what to expect and how to respond appropriately to all the data privacy risks and requests for extensions of people's exercising their rights.
And Kyle, let me hear from you, and then we'll wrap it up.
You need everyone in your organization bought into this. You need your board of directors to understand their role and the risks to your organization, the C-suite, legal, IT, all the business units. If you make privacy the role of IT or legal, it's not going to be implemented as you need it to be compliant.
Yep, that's the only stern lectures I get from anybody now at 56 years old is from my IT people to do my security training. So this concludes our webinar. Thank you, everyone, particularly our panel. This was, I thought, great, and we'll look for you again, everybody, both on demand and also in the other parts or segments of this great compliance series. Thanks, everyone.